All righty. Thank you, everyone, for joining us this evening. My name is Taisha Preston, and I am the administrative assistant for SCMA. Welcome to today's webinar, When Should You Mediate Your Case? An Attorney's Guide to Assessing when a particular case will be ready for mediation and to uh, completing necessary preparations before you mediate. This webinar is eligible for 1 hour of MCLE ethics credit. And if you are requiring MCLE credit for attending this event, please check in by putting your name and your state bar numbers into the chat. Once again, I will be shortly adding a link into the chat so that you guys can get the handouts or access the handouts. And please just make sure that your first and last name that's with your bar number matches what you're registered as at the bar. Thank you so much, you guys, and enjoy the webinar.
Thank you, Taisha, so much for the introduction and for setting all of this up. And welcome to all of you. Thanks for attending. I know we've had a full week already and it's not over yet. I'm Jim Cameron. I am the co-chair along with Craig Lang of SCMA's Attorney Outreach Committee. And we're delighted that you can join us for this program, which is actually the first of several that our committee will be presenting this year. They all focus on how attorneys can better serve their clients through the effective use of mediation. We have 3 expert mediators with us this evening, all of whom are still licensed attorneys who hope to provide some insight into the delicate subject of when you should mediate a case and how you should prepare. And I'll introduce our distinguished panelists in just a couple of minutes. A couple words about your program materials. You have our outline, and at the bottom of it, there is a list of 3 attachments, which Taisha will be sending out to you. One of our panelists, Meyer Sankary, has kindly shared these 3 attachments with you this evening. One of them is a PowerPoint presentation, which we'll be touching on during the course of our discussion. We encourage you to review these materials in detail as they will give you a lot more in-depth perspective into the subjects that we'll be covering. We'll save a little bit of time at the end for questions. If you have questions, please put them in the Q&A. Don't put them in the chat. And we'll try to address as many as we can at the end of the program. And if we need to go a little longer, we go a little longer. Now, a few introductory words about our topic. All of you know that nearly all cases which get filed in court settle one way or the other. Very few actually go to trial. And we'll share some specifics with you in just a minute about how few cases percentage-wise actually do try. Add to this that the courts are extremely overwhelmed with cases right now, especially LA Superior Court. The backlogs are getting longer and longer, especially in civil cases. And more cases are pushing up against the 5-year statute, believe it or not. The courts increasingly need to rely on mediation to help resolve their case backlogs in a productive way. One of the things we'll show you is Presiding Judge Tapia's report on LASC's caseload from last year. This backlog has led the court, among other things, to create more dispute resolution programs and to embrace more relationships with existing organizations that offer mediation services. One such important relationship is with the Mediation Center of Los Angeles, or MCLA, where the court has created both a vendor resource relationship and, as of last year, a direct referral program. The judges are now literally ordering parties to mediate their civil disputes with MCLA and to complete the mediation soon thereafter. As it happens, all of us presenting this evening do serve on the MCLA panel, and indeed, Meyer Sankary himself founded the organization, which used to be known, for those of you that have been around for a while, as the Valley Bar Mediation Center. All of this begs the question of when is the optimal time to mediate a case? And that question begs the further question of whether the court actually understands the readiness of a case for mediation when it orders a case to mediate. Okay? Ordering a case to mediation too early often results in no settlement. So the case is still on the court's docket. It hasn't helped the court's problem. We'll talk a bit later about how counsel can advise the court about case readiness so that hopefully you can get the timing right. And also what counsel should do proactively to get their cases ready to mediate earlier on. This begs the question of how to spend your client's money wisely. One final thing. Not all cases are created equally when it comes to how best to prepare. And as you will hear from our three panelists, different kinds of cases present different preparation needs. We'll discuss that with you in some detail starting in just a few minutes. So with that backdrop, let me introduce you briefly to our three panelists. You have their full bios in the written materials, so let me just give you the highlights. Let me just start with Meyer Sankary, since I've already mentioned him a couple of times. Meyer has been one of the leaders in mediation in California for many, many years. He's a past president of SCMA. He's been active with all the state bar committees on mediation and ADR. And as I said, he founded the Valley Bar Mediation Center back in, 2013, Meyer? And it has now been renamed as MCLA, the Mediation Center of Los Angeles, which has two separate contracts with LA Superior Court for discounted fee mediations in civil and probate cases. Now, Meyer, in theory, just celebrated his quote-unquote retirement at the head of SCMA, MCLA. There was a gala dinner at the end of February. He was feted by, among others, Judge Jessner, the immediate past presiding judge, who extolled all of Meyer's virtues. You may have even read about the event in the LA Daily Journal. He's technically no longer the president or program director of MCLA, but trust me, he's still very active, and he's been also a pioneer in developing the field of pre-mediation. We'll have a short discussion about that. Look, Meyer's revered by judges, counsel, and fellow mediators alike. He's going to talk about mediation readiness in a couple of kind of cases that are near and dear to his heart, probate and real estate. I'm proud to call Meyer my mentor, my boss, my dear friend. Meyer, thank you so much for being with us this evening, and we look forward to receiving your wisdom. Now, let me next introduce you to Bill Malfetta. And do we have Bill's name listed correctly?
I think I'm still listed as Meyer, but
all right. So yeah, now you know who's Bill and who's Meyer, right? And we don't know what's happening. Bill Malfetta, another dear friend of many years, comes to us from the world of insurance in his capacity as a lawyer and now mediator in neutral. Bill served for a term as director on the SCMA's board of directors, and he's now a panel mediator, as I said, with MCLA. His specialty is mediating personal injury, insurance coverage, and business disputes. Over the course of Bill's career, he's resolved well in excess of 1,500 lawsuit disputes and personnel matters. He was managing counsel for more than 25 years at an in-house litigation firm for Fortune 500 insurance companies that included the likes of Aetna and Travelers. You may have heard of them. He's also got extensive experience in first-party insurance claims, coverage claims, and subrogation matters, and he happens to have a special interest in uninsured and underinsured motorist mediation. Bill's been a great colleague of mine for many years. Obviously, we're going to hear him talk about the needs of insurance-related claims in mediation. He's one of our top experts there. So Bill, welcome and thank you for your sharing on that.
Thank you for the kind words, Jim.
You're very welcome. Finally, I'm delighted to introduce to you Mekon Shelton. She's a brightly shining light in the field of employment mediation. She comes to us from the world of entertainment. For once, we get an entertainment specialist on our panel. Mekon has more than 25 years of experience as a litigator, first with the Quinn Emanuel firm, then as an in-house employment lawyer at Fox for film, television, sports, studios, the whole thing, and as a senior executive championing, dare I say it, diversity, equity, and inclusion.
Say it. Mm-hmm.
DEI, yes, at Fox and Warner Brothers Discovery. Mekon brings a wealth of experience to her role as a mediator and arbitrator. She has successfully litigated, negotiated, and mediated hundreds of disputes and handled high-profile and stakes matters in film, television, and sports industry matters. She's a proud member of our Attorney Outreach Committee at SCMA, and like Bill and Meyer and myself, on the panel at MCLA for LA Superior Court. She's a dedicated, gifted problem solver and really knows her stuff with employment mediation. So Mekon, we're delighted you could join us, and we look forward to your wisdom.
Thanks, Jim.
You're very welcome. So with that, folks, let's transition to our first big topic, which is each of our panelists' individual presentations about the different demands and needs of various kinds of dispute when it comes to mediation readiness. And as I hope you can see from the three contrasting case studies, different areas of law practice tend to have different needs about how and when you should be ready to mediate. So Bill, I'm going to ask you to start, since you know all this stuff about personal injury and insurance-related disputes, and I know you've got a case study to offer as an example. So Bill, you've got the floor for 10 minutes, and if you start getting long, I'm going to come interrupt you. It's all yours.
Thank you very much, Jim. And again, thank you everybody for being here today. As Jim mentioned, my area is primarily personal injury. I come from an insurance defense background. I've been an independent mediator and on the MCLA panel for about the last 12 years. I wanted to talk a little bit about preparation and timing of mediation in personal injury cases, and looking at it from the perspective of the plaintiff's counsel, what I've experienced and what I think some suggestions on what plaintiff's counsel should emphasize in order to increase the probability of getting your case settled. So we'll talk about a couple of things. With regard to preparation, before the mediation, I suggest that you get all of your clients' medical records. Oftentimes, I found that some attorneys will rely on just the medical reports and the bills that they receive from treating doctors. On the defense side, they go a little bit deeper. And I worked on the defense side. The defense side will subpoena your client's records from any medical provider that they become aware of. And oftentimes, when they dig into your client's background, they get information about prior accidents, prior injuries, similar injuries. Sometimes I found plaintiff's attorneys are at a little bit of a disadvantage, and they're caught off guard because during the mediation, the defense side will bring up information about their client's background and prior injuries that they weren't aware of. And this is somewhat related to the case study that I had mentioned to Jim and the group earlier, I mediated a case 3 or 4 weeks ago, and it was a case of clear liability. It was a rear-end auto accident. The plaintiff was an outstanding witness. It was a very clean case. It looked like a case where plaintiff's counsel would be able to maximize recovery for his client. However, during the course of the mediation, the defense counsel and the insurance carrier had indicated to me that they had some information that they wanted to hold back. We did this in our private session. They said, we want to hold this back until we get close to settlement, because we think this might be influential information that will cause the plaintiff's counsel to drop his demand. So we went through the normal course of the mediation, and as we were getting closer, the counsel suggested that we have a joint session with all counsel and myself. So we had a session with myself, plaintiff's counsel, and defense counsel. At that point, defense counsel advises plaintiff's counsel, did you realize that your client had a prior automobile accident about 2 years before the case in question? It took plaintiff's counsel totally by surprise. He didn't know about that. And he was upset because he had a personal relationship with the plaintiff. He said, I'm surprised my client didn't tell me about this. The other issue that came up was related to what was in the medical records. When the defendants had subpoenaed the medical records, they found out that from that earlier accident, the plaintiff had an MRI, and the findings were exactly the same of the findings that were taken in the MRI post the accident that was the subject matter of the mediation. Another issue that the plaintiff's counsel did not know of, primarily because he didn't have access to the medical records from the prior accident. Well, this caused the plaintiff's counsel to be upset at himself, I think, and his client. And the long story was that the case settled for a significant amount less than what was anticipated. Could have been avoided had counsel known of the prior MRI and the prior accident. He could have brought that up early on in the mediation, and he could have diffused it, but he was at a disadvantage. So again, it goes back to the issue of getting those medical records, knowing your client, so that you're not blindsided during the mediation. So those are a couple of suggestions. The other significant suggestion that I have is, if you're handling a personal injury case and liability is not clear against the defendant, I suggest that you take the deposition of the defendant, or if it's a commercial party, take the deposition of the PMK to come up with some information that you can use during the mediation to persuade the defense side that it is in fact a case of liability. If you don't have that information, I found that you can be at a disadvantage. So those are a couple of things on personal injury cases, primarily automobile or premises cases. I also do some insurance coverage mediation, and a couple of suggestions there. If you're doing an insurance coverage case and you're representing the plaintiff, you're most likely going to be up against very, very competent, top-notch defense attorneys. I found that if an insurance company is a defendant, they're going to hire the best lawyers around to defend themselves. In those cases, again, do preliminary discussion, do request to produce documents to get insurance policies, the insurance policy manual on how they handle claims, and then take the deposition of the PMK from the insurance carrier prior to the mediation. That will be very helpful and significant in trying to persuade the insurance carrier that you know what you're doing and that you're going to put up a strong case to try to obtain coverage. With regard to timing, when is the best time to suggest mediation and then to proceed to mediation? oftentimes an insurance carrier will be amenable to mediation prior to them obtaining a defense or an independent medical examination of your client, or prior to the taking of expert depositions. The reason being that they're going to save a significant amount of money by not incurring the expense of the IME or submitting to the defense expert deposition. So if you can get the mediation scheduled before those events occur, they have that extra money in their pocket, and that might go towards sweetening the pot on the settlement. So the other suggestion is, if you're handling a personal injury case, you want to make sure that you presented all of your information to the insurance carrier and your defense counsel. I would suggest at least a month before. If you hit them with surprises at mediation, additional medical records, additional medical treatment, information that they didn't have when they evaluated the case prior to mediation, you'll probably get a response, well, this is new information. We're going to have to go back to our claims management to review this case in order to get additional authority, and your mediation is not going to be successful. So try to get all that information together. If you have some new current information, contact the defense lawyer and say, listen, we've just gotten this information. I know it's significant. I want the insurance carrier to have this information so that they can evaluate it, to evaluate my client's case, and continue your mediation for 2 or 3 weeks if possible. But if you hit them with new information on the day of the mediation, most likely you're not going to get your case resolved. Jim, those are the highlights that I wanted to bring up. If there are any suggestions you have or questions, let me know.
Yeah, no, that's great. And, folks, those of you who are listening, keep in mind each of the paradigms that we're talking about here in terms of what really helps and what doesn't. And you'll see as we get into Myers and Mikan's presentations that different areas of practice have somewhat different needs, but because we're all trying to get our cases resolved through mediation. So, Bill, thank you for that. We'll be back to you in a little while. Meyer, I know you've got a bunch of stuff to share, so the floor is all yours.
Well, I'm not sure how much I can get in this. I've got about 5 minutes left because thank you for the generous introduction. It wasn't really needed. I appreciate that. And I am honored to be here with such distinguished mediators. You guys are really top notch. I've interviewed all of you. I started MCLA back in 2013. When the court abandoned its ADR program. It's now refurbished these programs and has multiple programs. There's about 9 or 10. If you attended the Appreciation Day, you would have heard from all of the different programs that the court has partnered with. MCLA is a major partner. We have 3 contracts with the court. I just want to let you know. The first one was in-person mediation in 2018, called the Vendor Resource Program. But then in 2018, I started using a thing called Zoom. And I thought it was quite useful for mediations in 2018. And I tried, and I used it, and it was quite successful. An attorney in San Diego, her client was in New York as a lender. And then we had the plaintiff, the defendant in Los Angeles, and his attorney was in Newport Beach. So it was natural to have an online mediation. And I'm off topic here because I want to point out to you that everything changed once we started using online mediation. When I showed Judge Jessner this new form of communication, she immediately saw the advantages and gave us a contract, which was the ODR contract, Online Dispute Resolution. We were the only organization that proposed to use it online, and we were the only one who got the contract. So we were the only and first to use online mediation. I'm very proud that we were on the cutting edge and the forefront And every one of our mediators were trained, and I made sure that they were trained by me to use online mediation, and it's been very successful. As you know, during COVID, everything went online. This changed the whole field because now we can have many, many ways of dealing with cases early on and later on by having these kinds of uh, uh, opportunities to meet online much more efficiently and much more cost effectively. So I want to show you, I'm going to try to find, I don't know what happened to my program, but I'm going to try to find it if I can. You know what? I'm afraid for some reason, here we go.
You got it, Meyer? Yep.
I think I got it. Okay.
Okay.
Can you see it now?
There you go. All right.
There I go. Okay.
Yep. Just folks, just so you understand, this PowerPoint is part of your program materials. Okay. So you'll be able to study it at your leisure. But Meyer, go.
Since I have only a few minutes, I'm going to hit the highlights, and I just want to provoke your interest in what I'm going to say. And then this is about a 10-hour program that I'm condensed into 1 hour, 5 minutes on a slide that there's on the slides that you're going to see. The first thing I want you to be aware of about reason why we have early mediation is because if you read Judge Tapia's comments in the recent issue of The Advocate, you would see what the dilemma is. There's only 582 judges, 36 courtrooms, 1 million cases were filed, 72,000 unlimited civil cases were resolved. Jury trials were only 2,407. So 98% of the cases get settled before trial, but there's only 3% that actually went to trial in 2024. The conclusion is that the access to justice requires a robust ADR program and early mediation. So the courts are forced to push these cases to you at the earliest date when they think it could possibly lead to a settlement. So you have to be ready for early mediations on these referral cases. I want to point out that in 2023, Ben Root and I worked on a contract for the court submission. Took us about 8 months, but we got the contract. And what did the contract provide? It provides referrals directly from court benches, from judges, directly to MCLA through our website. And we have an automated system that now is able to handle what was last year over 1,000 cases that came in and assigned to 25 mediators. And we're expanding that program now, and we hope to add more mediators in the coming months. But I wanted to point this out to you because it's the condition of the court that's forcing as early mediation as possible. Judges now have, instead of maybe 400 or 500 cases on their docket, they now have 800. How do they get rid of them? They sign orders to send them to referral. They send them to us. They can send them to the new MVP. They can send them to Resolve. They can send them to local organizations. AAA is now doing vendor resource. And so you have a whole bunch of programs now. But we're the only ones that insisted that our mediators get paid a minimal fee of $300 an hour. That differs from every other program, which is all free. There's a big difference between free and quality mediators who are, being paid, and it focused the attention. So I'm very much in favor of paid mediation for lawyers, for mediators. I think it demeans the profession when we do it all for free. I think it's good to do service. I think it's good to get practice, but we need to be paid. So I want to change everybody's mindset now that dispute resolution is not a one-day event. It's a continuum over time. And this is a little chart you can study of what time on the timeline from the time a case is disputed, at what time can you have intervention by professionals. And then when is the optimal time for a negotiated settlement? Here's a spreadsheet that I prepared. You can take a look at it. There's too many things to discuss in this program. But you can see the most important things for early settlement is cost effectiveness, time savings, and also preservation of relationships. If you can get there early enough before positions harden. And so I've got a chart here that says, when is the optimal time? Have you thought about, is there any data that shows when is the optimal time for negotiating a settlement of a litigated case? And lo and behold, if you ask our friend ChatGPT, it will draw you a graph to show you when the peak opportunities occur about 1.5 to 2.5 years into the program. But what are the elements that are factors that make the optimal timing? And you'll see discovery status, completion of discovery, emotional readiness, cost efficiency, case momentum, evidence freshness, legal disputes, and so forth. You can see all of that. But now, if you notice here, the graph only shows what happens from 1 to about 4 years. It did not show what happens when you're on the courthouse steps. So I asked what happens on the courthouse steps, and I think you would all agree that many cases get settled right before the trial. But you've lost all the opportunity for cost savings, for opportunities for relationships, et cetera, et cetera. Please study this, and I'd like your feedback. I think it's very interesting. It enlightened me, and when you see it graphically, I think you have a better idea of why you should try to optimize the time of settlement. And so there are perils of early settlement. I mean, there's power imbalances, the impact of early mediation. The parties might not be ready. It's important to share information, etc. Again, study these particular items. You can do more by some more research. But early mediations, if they succeed, can be very, very useful. And I believe that the success depends on preparation. And I am a huge advocate for pre-mediation. I believe that most of the mediations that fail are because the parties were not prepared. They didn't exchange information. They didn't complete their discovery. They didn't do things that were essential. And what you can do in pre-mediation is have a joint video conference with attorneys and outline what needs to be done and ask the question, are you prepared to mediate in the next 30 days? If they say no, then say, what are the steps that need to be taken to be ready? And if they then tell you that, then set dates when they have to be completed and when a mediation date is ready. Then you can ask, how long do you think we'll need for the mediation? Just as a judge asks before trial, how many days do you think it will take to try this case? You will not go to trial unless you tell the judge how many days you want the judge to reserve for trial. Same thing in mediation. You need to ask, how much time do you want to put into this mediation? Is it a 3 hours as the minimum is for our cases from referral, 3 hours? Or do you want more? And it's better to know that in advance. So anyway, I think it's really important to consider what questions and how to maximize your settlement opportunities. I've thrown out a number of issues and questions that you can ask. I'm not going to go through it. We don't have time. But I do want to point out one big thing. I attend several programs on advanced MCLE programs, and one of them was about civility, and that's a big issue in California now. And I think you should take a look at the Business and Professions Code and the rules of ethics, because one of the things that they point out is civility requires respect and consideration for the others, not to use personal attacks, insults, or intemperate language. And in fact, I was on a conference with probate judges, and one of the things they said, and because it's now online, these trials are often on video, they can see your face. And when one of the judges complained that too many litigants, clients, are not coached by their attorneys to be civil and to show them the guidelines for proper behavior in front of the judge. I want you to be aware of that, because civility is a major issue and judges are looking at that and they will complain. So anyway, I want to talk, you should take a look at the civility statute, and I'm giving a program on how to apply the principles of persuasion to early mediation so you can get a good result. So these are my thoughts. If you're interested in books, you can see in the PowerPoint, I have some interesting books for you to read. Anyway, I hope this was informative and helpful, a new way of looking at things. The most important thing to take away is the pre-mediation readiness conference is the same as trial status conference. You don't go to trial without having told the judge that we've got witnesses, we've got documents, we've got everything ready to go. The judge will not put you into a trial unless you have everything ready. Same thing in mediation. I can't emphasize that enough. Whether it's early or late, be prepared.
Thank you so much, Meyer. I'll say a few words after Mikan speaks about the specific needs in what we would call financial records type cases. Meyer and I both overlap in doing probate stuff. But Mikan, I really want to give you the floor now so you can talk about the somewhat different dynamics in employment mediation. And if you want to share, an inside scoop story about what's going on at Sony, well, we
Yes,
we
everyone wants to
welcome the
hear
dirt. So anyway, the
I
floor is
will not be talking about the Justin Baldoni case today. Not today.
no.
I will be talking about a case. Meyer, do you mind if we stop sharing screen?
Yeah. Meyer,
Oh,
yeah,
no, I'm sorry. Oh, yeah, sure. I thought, well, I had. Okay.
There
No,
you
that's
go.
okay.
We're good. All right. Thank you.
There we go.
There are unique
Thank you.
aspects of when it comes to employment, but I think the big themes and the big picture issues that Meyer and Bill laid out actually do apply really well to employment. So I will just jump into my case study because I think the case study will illustrate a lot of the points that Meyer and Bill talked about. So I'm going to talk about a case that I just mediated earlier this year. The plaintiff was a nurse. She was young and new in her career, but very good, very capable, very well respected nurse at a regional hospital. And while she was there, everything was going well until she heard rumors and gossip that people were saying that she had slept with a couple other people. And then there was some teasing that maybe there was a threesome going on. And she eventually complained to Human Resources that people in her department, including her supervisor, were joking around about this issue, and she felt that was sexual harassment. And she believed after she reported that incident that she was then the subject of retaliation. And she thought that her supervisor and others were starting to ice her out. She thought she was getting micromanaged and that she was given less desirable shifts. Okay. So then she complained again to HR, and the HR department looked into things. They addressed it. They talked to her about her shift. They talked to her about what she called micromanagement, but what they thought was a breakdown in communication and just very, kind of run-of-the-mill management issues. So, she goes back to work and things do not get better for her. And so she complains a third time. And she says this time she even felt like, they might take this as petty complaints, but for her, it was cumulative, being told to, go get coffee, being told that, she's the one who should clean the kitchen up, like these types of things that she felt in the context of all the other issues that she was facing was something that she wanted to have addressed by HR. And HR did address it, but still she felt that she was continuing to be marginalized and micromanaged. And it got so bad and she got so stressed out that she went out on a leave of absence. It was a workers' comp leave. And then in the course of settling her workers' comp claim, she separated her employment. So this all happened last year, 2024. She separated from her employment in July 2024. By August, she had filed a civil complaint, and in January, we were in mediation. So that's pretty quick in kind of the case timeline, right? So, but I think here, this case illustrates really strong points about early mediation because the attorneys on both sides were very prepared and they did a great job coming to early mediation. And then they did a great job in mediation. And this is what I'll share. So we get into mediation. The plaintiff was still very upset. You know, this was something that, again, early in her career, so formative years, she's still developing her sense of self. And so this kind of rocks her because she thought I was doing a great job. People thought highly of me. And now I'm out of a job because of, you know, things that, you know, happened to me by other people. And so, you know, she felt she had not been taken seriously. She felt very insecure. She felt, you know, gaslit because the hospital kept telling her that they had addressed her problems. And then she, you know, had faith in them and trusted them because they were so sincere every time they said, we've addressed this. And she goes back and she's just confused that nothing felt addressed to her. On the hospital side, they, you know, they brought their outside counsel, they brought their general counsel, they brought their insurance carrier, and they had the department head, the head of all the nurses, not the supervisor, but the head of the nursing department there at mediation. They're like, we did everything right. We did everything so that we could, you know, have the best hospital staff. It is a tough job as it is. We are going to address issues that come up. She was good. We don't even actually understand what happened because we thought she quit. Here she says in mediation, well, I didn't quit. You fired me. Her understanding was perhaps a misunderstanding with her in her workers' comp claim that she had to quit in order to settle that claim. And I don't know where the breakdown in communication was with the workers' comp, but that to her caused her to have even more distrust because in mediation, she's being told now I can't trust that workers' comp attorney who was advising me. And did I get a bad deal there, right? So there was just a lot of distrust that we started with in the beginning. But we had to work through that, and we had to give her a lot of, you know, time and space to work through this. And she worked with her attorney. She was asking her attorney questions. She asked, you know, me a lot of questions about, you know, does any of this sound right to you? Because she felt like she was being like fully gaslit through this whole thing. So, you know, we work our way through it, explaining to her the hospital's viewpoint, right? Because she'd heard it but not really heard it. And so explaining to her why the hospital values her case so differently than she does is because they think every time she went to them, they addressed the issue. She was adamant that nobody talked to her about that first issue of sexual harassment, which she thought was the most serious. She's like, look, I get the other stuff might not sound like a big deal, like micromanagement, the way they talk, the way my supervisor talked to me was gruff. No, she never called me names. No, she never did anything like beyond that. And then, you know, those other things were getting increasingly small, but they addressed those things. But I don't understand why they didn't address the big thing of sexual harassment, which was really the thing that was ruining my career. So go over to the hospital and he said, okay, she is saying that nobody got back to her and she's adamant that it was not investigated. So in the hospital's room, they, much to their credit, really went through this and said, wait, are we misunderstanding something over here? Because how could we be so off? So it turned out that somebody else had complained about the gossiping because the gossiping was working its way around. So obviously other people heard, and because of the allegations of a threesome, there were obviously two other people subject of this rumor. And so when those complaints had been raised, the HR from the other person, the HR department looked into it, talked to her in the course of that investigation, and then addressed the complainant there. By the time this plaintiff complained about it, right? sometime later, because she believed the rumors were still going, the HR department thought, oh, we had already investigated that. We had already addressed that. So we don't need to do it again because we already had, right? And so in the course of this information exchange, there was, again, I give the defense room a lot of credit, openness to hearing, wow, did we miss something? And so we actually took a break in the mediation. We ended up doing this as 2 half days rather than a full day, because the defense room said, look, if we did not value this case based on sound facts, or if there are more facts we need to account for in the way we value this, we want to go do that. So let us go have some time to look into this, and then we'll come back, because they were like, this is nuisance value. We don't, you know, we have no money on this. Like, and then they said, okay, wait, here's where there was a breakdown. There's a breakdown in communication. There's a breakdown in, you know, understanding. So we ended the mediation for the day. We scheduled a second day to occur, I think it was like 3 weeks later. And then when we all came back, you know, there was some acknowledgement, which went a long way in the plaintiff's room. She was like, okay, I knew I wasn't crazy, but you're all acting like I'm crazy, right? So that was the first part that started to really like open things up. So in the course of then, we were like, okay, well, still, hospital still says still, right? Even if we miss getting back to you, that is not like failing to investigate. That's not failing to address the issues, because we still believe we addressed it. We just didn't tell you, direct our communication towards you that first time. Second time, third time, everything is fine. So they said, okay, so their assessment was still a certain way. I said, okay, let's put liability issue for aside for a second. Let's talk about damages, right? Because again, so early, she just lost her job in July. Now here we are in January. Defense is like, what damages has she even suffered? Such little time. And nurses are in such short supply that she should be able to get a job. I don't know. We don't know why she's not already working, right? She must be failing to mitigate. She's over here saying, I am trying, and I actually don't know why I can't get a job either, because I'm a very good nurse. I'm very capable. And so I don't know if they're bad-mouthing me over there. So whatever it is, I'm definitely mitigating. And I mean, she was pissed. Like, I don't know why I'm not getting work. You know, from us, when we're sitting there looking at this, we can imagine, okay, well, maybe you're not interviewing at your best. Maybe you're not, like, there are other things that could be going on, but she's starting to assume that it's because the hospital's bad-mouthing her. Hospital's assuming, wait, you must be loafing around, failing to mitigate, and so damage is going to be cut off anyway. And so we started exploring this. Like, okay, why? Both sides are so certain about certain things, right? So I said, okay, what if we weren't so certain about this? And what if we like looked at this in different ways? You know, and they said, no, we are very certain that she should be able to get a job, because we cannot hire nurses fast enough. Nurses are in short supply, and we don't have enough nurses. We have vacancies all the time. And so then this, yeah, maybe you could see this is like aha moment, right? Because the nurse is like, well, I still want to work and I need a job. So in the course of talking about damages, this opportunity came up that, or this idea came up that we could rehire her. And could that be part of the settlement? And could we talk about the terms of a rehire? Who should be working with? What had happened in just those few months is her supervisor had moved into a different role, and the other nurses who were a part of some of the gossip and rumors had left, because again, the hospital's like, nurses are getting poached, nurses are getting hired away. We cannot keep them long enough. And so the other people who had been involved had left, supervisor had moved to a different role. They need nurses. The department head was there, a participant in the mediations, so could hear all of this. And they had all the right people in the room for us to really think that through, because, you know, you don't take that lightly, because you're bringing back somebody who there was such a rupture in trust. Can you rebuild it? Is there going to be, you know, kind of suspicion and distrust that they will not be able to overcome, and that will lead to bigger problems later on? Like, defendants brought enough people into the room, decision makers, to be able to work through those issues. And we were early enough they were early enough in their litigation that they had not really hardened their positions about each other. They had not like decimated the relationship. There was still a little bit of goodwill that then in mediation we could build back up. And so it turned out to be a great solution for them. I mean, the defendants, once they really got their heads around it, they're like, okay, this really makes sense to us. So they wanted to offer it to plaintiff. Plaintiff, I'm going to say, was not immediately thrilled by the offer because she didn't trust these people, right? So we had to really talk through it and what the parameters would be. So through the course of that second day, we were able to come to a resolution. And I think a lot of that had to do with the timing and the ability for us to get everybody together early before any, scorched earth litigation tactics really just, ruined the rest of that relationship. So I think that case demonstrates a lot of what Bill and Meyer have said. So
It certainly goes, Mikan, to Meyer's point about not just the benefits of early mediation, but making sure that you have the information necessary. And on that point, to the fact that mediation is a process, it's not an event.
Right.
And, Meyer and I have discussed this a number of times. We've had cases that will go 2, even 3 sessions before they settle. But that goes to the preparation question, which is ultimately what we're talking about here, which is, do the parties have the information they really need in order to make informed decisions? And what I'd like to do at this point, and I don't want to push up against our question and answer period time too much, but just let me give you a for instance, which is in probate and many business disputes, when you're talking about disputes about financial accounting and that sort of thing, and I want our audience members to, to understand this. You've got accountings presented to the court, okay, because you have an obligation to report this, that, and the other thing. How do you, on the other side, have any ability to evaluate whether those accountings are legit or garbage if you don't have the backup bank records, receipts, copies of checks, and all that kind of stuff? You say you spent this money, prove it. And how can you mediate that? You have to empower your clients to be able to make an informed decision at mediation, okay? And if you go into mediation and you have no clue what good or bad there is in the other side's position, how do you mediate? But what I want to share in particular is different kinds of cases require different kinds of preparation. With personal injury stuff, apart from getting the basic insurance documents and doctor's records and that sort of thing, in Bill's situation, kind of comes down to the people, right? In Mikan's area, it's not document intensive particularly at all, is it, Mikan? Right? It just not always. So you don't need to go very far into quote unquote discovery in order to handle those kinds of disputes. When it comes to like financial accounting cases, that sort of thing, if you haven't had complete document discovery, forget about depositions. If you haven't had document discovery, how on earth do you mediate the case? So I want to transition into kind of our conclusion here. Different areas of practice, folks, have different needs when it comes to being ready for mediation. You don't have to have every last T crossed and every last I dotted, but you have to have enough information as counsel, and you certainly have to empower your clients to be able to make an informed decision when they get to mediation. And to both Bill and Meyer's point, if stuff's coming out at the last minute, you may need to postpone things a little bit. And you know what? That's okay. But I want to conclude my stuff, and then I'll give these guys a chance to chime in here before we go into questions. You get these orders from the court to go mediate, right? You folks all know that. And doesn't matter whether it's a referral order to MCLA or just go pick a mediator and come back in whatever time. What does the court know at the moment that order is issued? First of all, when does the order come out? It is at a case management conference, right? Who's at a case management conference? The lawyers. At that case management conference, what does the court know about the state of discovery in the case? Typically, nothing. Why? Because unless there is a discovery dispute, discovery requests and responses aren't part of the court's record. Okay? So, counsel, thank you for continuing to listen. It's your job at that CMC, when the judge says you really need to go to mediation, you need to be in a position to assess the readiness of your particular kind of case for mediation. And if you need more time because discovery isn't complete enough, tell the judge before he or she enters the order. Because you're going to get not only an order to go to mediation, but a mediation completion date, right? And the court will set a PMSC, post-mediation status conference. Do you want to be in the position where you have to go back to the courts saying, oh, judge, we need more time. We weren't ready enough. Because the court may not give it to you. Get it up front. Tell the judge you're there in court, whether online or in person, at a case management conference. Judge, we need to complete this discovery. And the judge is going to say, okay, fine, get it done. But the judge will give you a little bit more breathing room at the front end so you don't have to go crawling back on your knees to ask for more time. Be proactive here, counsel. The court won't know from the state of the docket whether you're ready to mediate or not. But the court has every incentive to send you out early. If you have the kind of case that requires meaningful discovery in a particular area, whether it's documents or witness interviews or depositions or whatever, let the judge know where you are. Now, if you're 3 years in,
Jim, I'd like to just throw in, because we're almost at the end.
yeah,
I think one important thing I'd like the attorneys to know is, number one, when you get a case and you take down the information from your client, think about it as though you're going to be preparing for a trial. What is the theme of your case? Who are the parties? What are the witnesses? What is the factual dispute? What's the law? Don't wait until you're a day before court before you start making this determination. That information is just as important for a good mediation, a productive mediation. And if you don't have that information, you're not really able to advise your client about the underpinnings of what it takes to make a decision, how to make a good decision, using decision tree analysis, doing cost-benefit analysis, all of that. Plus, you should discuss with your client the BATNA and the whatnots and all the other things. You should prepare the client and prepare and manage expectations of what a mediation is about and what can be achieved. And it can only be achieved if we can share information sufficiently that the other side can say yes. So that's the whole point of mediation. And that changes from litigation advocacy to mediation advocacy. And I've got a whole program that's going to take about 5 to 10 programs to go through all that. It's a big subject. It can't be discussed in 1 hour. So I just want you to be aware there's a process and you need to prepare your case, because the better prepared you are going to mediation at any phase, or even opening up private discussions, you have a better grasp of how to discuss your case with the other side and think about the elements of persuasion, basically the principles of persuasion that you can use to get the other side to say yes, only if you're prepared.
Yeah.
That's my closing comment.
Well, thank you. Bill, what would you like to suggest to us? And make sure to unmute yourself.
I'm unmuted. Yeah,
Yeah.
here's another useful suggestion. Let's say that you mediated for a half a day, so typically 4 hours, and you've come closer in your negotiations. Your settlement demand and offers are closer than they were at the outset. But for one reason or another, let's say that the insurance carrier does not have additional authority, and they may have to go back to higher ups within the company to get additional authority. Most mediators will agree to follow up. And a lot of times they won't charge you any additional fees for additional follow up, whether it's, a few telephone calls, emails, etc. So inquire with your mediator. Say, listen, we've gotten closer, but we're not there yet. We want to try to get more authority. Plaintiff's counsel may be willing to discuss with his or her client the realities of settling versus going to trial. And they'll ask you, can you follow up with us in a week or two? And that can be very beneficial in getting your case resolved. I've had a few cases within the last month where we did that, and we were far apart at the beginning. We moved closer at the end of a half a day, and eventually we were able to get settlements. So inquire with your mediator about that. The other technique that works sometimes is a mediator's proposal, where if both sides agree that we're close enough that we may want to consider further settlement discussions, but the mediator's input and view on what he or she thinks this case should settle for, a mediator's proposal may work. And I think most mediators are agreeable to doing that. I generally would agree if both sides say, yes, we want a proposal. And if I think that I can come up with a settlement recommendation that each side will seriously consider. And you'd be surprised, they give a lot of weight in most cases to a mediator's proposal. And when they go back, discuss the case with their client, or if they have to go to a higher level of authority, they talk about the mediator's proposal, and you can have relatively good success in getting the case settled that way. So those are two issues that I wanted to bring up, which I think can help you resolve your case post the initial mediation conference. And that goes back to Meyer's point, that mediation is not a one-day event. And we saw that in Mecon's case, where they continued for a couple of weeks and they came back. So keep that in mind. If we don't settle at that first half day, still keep an open mind with regard to future negotiation.
Yeah. Mecon?
Yeah. So I would echo what Meyer and Bill have said, and I guess I would something that you all haven't mentioned, so I'll say, really, really try to get all the decision makers there for the whole time. I know with Zoom is so great. I do everything on Zoom, but it does allow for insurance carriers. It does allow for counsel to think, oh, you know what, I'll drop in and out. I'll be available, when you need me. But there is something so useful to having all the decision makers there to hear how things unfold, especially when it's early and there might still be some information exchange. I think that's very important and very helpful for early resolution. And then, Jim, I want to thank you for inviting me to be on this panel, and thank you for allowing me to jump off and not be here for the Q&A because I have another event to go to. But it's been such a pleasure to be on this panel.
Well,
thank you all.
Thank you so much, Mecon. We appreciate
Thank you,
it.
Mecon.
Thank you.
Yeah.
Enjoy the judge's dinner.
Yeah.
I hope it's not just chicken.
God forbid, right?
All right.
It's there. We've got a couple minutes that we can go over here and take a couple of questions. One is from John Zorbas, and I'll just read it, and Bill and Meyer, you can chime in on this one. It says, Superior Court judge orders a case sent to mediation. After each of the attorneys at the case management conference have agreed to try mediation. Mediation is to be completed in 6 months. The judge assigns the case to a mediator. Thereafter, the mediator contacts counsel. Counsel, or at least one of them, does not respond to the mediator's request for information, setting a schedule, etc. The lawyers do hire the mediator, but for another case. What, if any, is the mediator's responsibility to the Superior Court judge for the case that was court ordered to mediation?
Well, can I respond
Please.
to that?
Yeah.
I think if the mediator receives an assignment from the court or through a panel like MCLA, the mediator needs to keep a record of who's responding and who's not responding. Typically, when the assignment comes in and the parties know who their mediator is, the mediator will send an email or emails to the parties requesting that they supply the time frame when they want to conduct the mediation. If there's no response within a reasonable time thereafter, the mediator should should do follow-up contact with the counsel. I mean, that's my practice, and I think that's what most mediators do. I mean, they don't abandon the case because they don't get a prompt response back.
Yeah. I mean, look, the mediator is not a party to the court proceedings, right? And we receive our assignments through a panel, or people can hire us privately, right? But the judge's order applies to the parties in the case who are before him, subject to process and all that good stuff. On a couple of occasions, I have been asked to draft a declaration because one side wasn't cooperating with the process. I've hesitated to do anything that formal, but if this goes to the question of the scope of mediation confidentiality. I don't think the confidentiality privilege extends to whether or not a party is cooperating with just getting the mediation set up. That's my personal view. Okay. But I still don't want to be filing anything with the court, but I might put something in an email to all counsel saying, this is where we are, and I'm not getting an answer from so-and-so. I don't know how to move things forward because, after all, mediation is not just confidential, it's voluntary. And even though the court can order you to participate, the court can't order you to settle. No court has that power, right? So, and let counsel take it back to the court saying, Your Honor, you ordered us to mediate. We contacted the mediator. He tried to schedule everything, and guess what? The other side isn't cooperating. Let that be the party's responsibility. But I mean, Bill Meyer, do you ever report to the court?
Never. No, that's forbidden.
Never.
Absolutely. No.
Yeah. I mean,
we stay away.
but-
In fact, let me just say, I've had personal conversation with judges over time who've supported our program. And one thing they've advised is the mediator shouldn't tell the parties to go tell the judge what to do. That's offensive to the judge. And that they don't expect the mediator to communicate with the judges on a particular case. So we stay away from that. And the main thing is that all we can do is say, here's some options for the parties to decide what they want to do. I have a case right now where I had a mediation, pre-mediation, the parties came, one's an unrepresented. She ends up, the unrepresented party doesn't show up at the mediation, where the other side is represented by counsel. I go ahead and have an hour discussion with counsel. The other party never showed up. And I've been trying to reach the other party. I don't know what happened to her. I don't know if she's still alive, sick or otherwise, but I can't tell the court, by the way, this party didn't show up. It's up to plaintiff and the attorney there to make that statement to the court. I'm finished with my effort of trying to contact the other side, having the pre-mediation, having the mediation on the day, and that's all I can do. Please do not tell the parties what to tell the judge. That was directly given to me by one of the primary judges who send us lots of cases.
No, that makes sense. Bill, any final thoughts that you'd like to conclude? We've been, imposing on everyone's.
Well, I would like to answer one interesting question that's been raised, a very important one, and that is the mediator's proposal. Ivan, whom I know and good friends, he points out that he would never make a mediator's proposal because he thinks that violates the neutrality of the mediator. It's moving from trying to help the parties voluntarily come to an agreement and inserting ourselves as to a way of recommending a proposal. Now, you could take the attitude, well, this violates the neutrality because you're now coming out and making a recommendation. On the other hand, it happens to be one of the more successful ways of getting cases settled. At least when I use it, in the way I've used it, I've always had a good success from it. People have never been offended by it. When I've asked if it's, in fact, at the pre-mediation, I ask, if there's an impasse, would you like a mediator's proposal? And almost invariably, they will say yes. Why? Because they know they need something from the mediator to go back to the insurance company to say, look, a prominent member of the bar who's experienced in this field has said this is a possible way of settling the case. It's not imposing the outcome on the parties. It's just suggesting a way of settling it. And if you don't agree, say I don't agree, and there's no settlement. You can come back with another.
If I could add to that, Meyer,
Yeah.
and I think you do this as well. I would only give a mediator's proposal if all the parties agree and ask for it.
Exactly.
One party says, I would like one, the other party says, no, I'm not interested. No,
Then you don't do it.
proposal.
Yeah,
If
absolutely.
everyone is on board, I think we maintain our neutrality and we're giving a recommended a number that we think each side may seriously consider and hopefully accept and get the case settled.
Yeah.
It addresses the needs and interests of both sides. So you're being very objective and neutral. And what you're doing is providing information that the other parties, both parties don't have all the information of what went in your confidential discussions, right? You're the one who's sitting there with all the cards. You know what each side has said, what each side has told you, what the risk and what the rewards are on each side. And now you are sitting there with valuable information that could settle the case. And somebody says, the mediator says, no, that you shouldn't do that because you're now violating your neutrality. And I say, you've got a different perspective than I do. And that's a good discussion. We can talk about the benefits and drawbacks of a mediator's proposal. What is the harm from it? And what is the benefit? In my case, the benefit is I settle almost all my cases by making a mediator's proposal with the consent of the parties when we reach an impasse. Otherwise, the case never gets settled. So I'm very passionate about mediator's proposal, and I'm sure Ivan feels just the opposite. And I'd like to hear his viewpoint offline when we can have I'd like to have a workshop on mediator's proposal, for example. We need a vibrant discussion of input. And I think what Ivan has proposed is something that's important to be addressed and be careful about when we use it. He also raised some other issues about using these confidential facts that we have gotten. For example, in a mediation, can we use the facts in our discussion? For example, in the case you described, Do you think it's violating the confidentiality by having discussed the facts of a case without relating it to names or when or who? I don't think so. I think if you, in our confidential agreements, we always have a provision that's required that says we may use the information for educational purposes without revealing the names, and the parties sign it. I don't know how I'm violating somebody's confidentiality if they've
Thank
agreed
you.
that I can use this information for educational purposes. What do you think?
No, Meyer, you're totally on the right side on that one. And look, we I see in the Q&A that we have some support for Mediator's proposal presentation, and we'll put that on our list. Look, we've indulged all of you in staying on this long, and we thank you for it. I hope you've gotten some benefit out of this conversation. I mean, yes, it helps to be prepared. Yes, it helps to know what you need to be prepared. Yes, it helps to know what your client needs to be prepared. And, spend your client's money wisely. If you need to spend a few grand doing document discovery in order to be able to have a chance of settling at mediation, spend it. But sometimes people don't want to spend any money, and then they go to mediate and the case doesn't settle. Now, what good does that do? That's ultimately the question. You're trying to empower the parties to reach a settlement. So make it possible. But, we thank all of you for attending this evening. I know that there will be, to answer a couple of questions that have popped up, a separate email from Taisha with the program materials and that sort of thing. There's a lot of good stuff in them. And thank you, Meyer, for those in particular. They're very valuable.
By the way, I invite the participants, if they want to send me an email criticizing, I'm open to all kinds of discussions on this issue. So really, I invite you to evaluate what I provided. I've done a lot of research in this area, and we have 1,000 cases. We now have experience to reach, to get data to make better informed decisions. When we have that many cases in one location that we have at MCLA, we are now able to better predict what's going on with our mediations, when the most optimal time are for settlement, how we get those settlements, and so forth. We're preserving a lot of data that we're offering to the court, which will elevate all of our levels of mediation experience.
Yeah. Folks, I see that for those of you that are still on the call, Taisha has just put into the chat the link to the handouts. Okay, so you can download them that way. And Taisha, we want to make sure that everyone who participated and signed up gets a copy, even if they have to log off early. But we'll discuss that later. Listen, folks, thank you so much for joining us this evening. It's a busy week, California Mediation Appreciation Week, or whatever we're calling it. SCMA has 2 more programs, one tomorrow and one on Friday, going out with a bang here. Some great stuff. So Bill, Meyer, and in absentia to Mekon, thank you so much for doing this. Obviously, we'll be talking very soon. And
thank you, Jim, for putting us together. Thank you,
Oh.
Bill, for your support and your excellent mediation skills and sharing it with us, both of you. Jim and I go back a long way, right?
Ancient history, right, Meyer?
Right, we are. And by the way, I'm still president. They haven't removed me as president.
Yeah, okay, good.
I'm still president.
Okay.
I have a little authority with MCLA. Okay.
God bless you, man.
Yeah, thank you so much, both of you.
All right.
Have a great week. Be safe.
Same to you. Bye.
Folks do as well. All right. Bye-bye.
I know.